Please unmute yourself, Mr. Mr. Mulgaonkar, could you unmute yourself?
Yes. Good evening and welcome everyone to this inaugural online talk of the association. We are grateful to Justice Naidu for graciously accepting our invitation to speak on the subject of free speech jurisprudence under the Constitution of India. We have got an early commitment from Justice Naidu, and in part fulfillment of that, he is giving today's talk. It would be presumptuous to introduce Justice Naidu, who is so well known to us. I only think that I would like to say that he has been a judge of the Andhra Pradesh High Court and Kerala High Court before coming to Bombay. He has authored many books, edited some, and he is a very well-bred person. And one thing that should gladden many of us, that he is very keen on cricket. And sir, we would like to see you on the ground in action. Welcome.
Certainly. Yes, Mr. Mulgaonkar, should we begin?
Yes, Mr. You can begin.
Yes. Shri Mulgaonkar and the other office bearers of the Goa High Court Bar, the learned senior advocates of all ages and stages, and my friends, good evening. The rains have stopped and the lockdown is lifted. You could have spent this weekend profitably and pleasurably, but you have chosen to listen to me. Don't blame me for that. You wanted to be my captive audience. You're welcome. You know, many people acquire qualifications to put behind their name or under their name, so they read long. But the day when I retire, I'll have at least half a dozen high courts under my belt saying that I worked there, I worked here, and Goa is one. And what a delightful experience I've had here. I'm really grateful to all of you for the time I've had here. And of course, the longer the better is my opinion now. And Mr. Mulgaonkar, the president, wanted me to speak on free speech jurisprudence under the Constitution of India. He has told me to spend 30 minutes on the topic and the next 15 minutes for interaction. So be it. Let me begin by sharing a cartoon I read when I was a school student. That was a story of a dog. One day, in any nondescript town of this country, a dog was walking. It was quite weak and emaciated, perhaps lack of nourishment. But it came across a new dog, a very well-fed, healthy dog. It never saw that dog in that area, so it said hello to that new dog, and it inquired, "Where do you come from?" And it says, "I come from another place, not this country at all." Then our curious Indian dog, it was maybe about 40 years ago, that's why you had to think of the conditions then. And our dog curiously asks the foreign dog, "You look very well fed, very cared for, but what's the trouble you have had in your country to flee and to come over here? You see my position, I've been emaciated, starving, nobody to care for. Why do you choose this place to be, after all?" Then the dog replied, "I come from a place called Russia. It's a joke, no national insults involved. There I don't have the liberty to bark. So more than the food, what matters is the right to bark." In dog's terms, it is the freedom. In our terms, to speak out of mind, perhaps, is a matter of freedom of expression or freedom of speech. Friends, to get into the topic, I would also like to underline the theme in the cultural terms. For that, essentially, I have to tell another story that of an anthropologist, a professor. I've always been telling, especially young advocates, to excel in profession, be a good storyteller. For a judge, it may not be the right thing, but for an advocate. And once I was an advocate, that's why you have to excuse me for that one. You know, that story was, it really happened. I read that anthropologist's book many years ago. This man went to the Amazon forest in Latin America with a native tribe of the Amazon. He stayed for about 14 years. He became part of their culture, rather existence. And he wanted to, in our modern terms, if we could call it, educate them. So he started teaching them all morals, or what we call by our standards morals. Then, to edify that moral, he told them the story of Hamlet, the Prince of Denmark. And he started telling like this. Friends, there used to be a very benevolent king, Denmark the Senior, rather the Hamlet the Senior. And he had a very scheming brother. He waylaid and killed him, in fact, when he was asleep, by pouring poison into his ear. Later, he used up the kingdom, incestuously married his brother's wife, and even tried to kill his brother's son, his own nephew. And this professor was denouncing the evil deeds of that younger brother, the usurper. Then the chief of the tribe stood up and he said, "What's wrong with that one? A king ought to be wary and really careful of his enemies. They could be inside or outside. And the fittest should survive. And he, being fitter than his elder brother, he just done away with him. Then whatever belongs to the successor should go to him. That's why he has had the kingdom. After all, in his language, I should quote, a woman is property, so is the king's wife. That's why she has belonged to him. And no fool will have an enemy surviving. That's why he doesn't want his brother's son to be there as a rival to him. So I don't see anything wrong in the deeds of senior Hamlet's brother deeds. Why I tell this story is, in any culture, freedom depends based on the level of that culture, its history, and various other unseen aspects. Therefore, Indian judiciary especially, even beginning from Ramesh Thapa to this day, has refused to import the interpretation put on the First Amendment by the US Constitution, First Amendment of the US Constitution.
No, now what we'll have to do is get
Somebody may have to mute. I've been listening to a lot of crosstalk. Now it's all right. Yes. Friends, pretty well we know that we fought for our freedom and got it in 1947. Of course, Goa a couple of decades later, though. We have had the Constitution enforced in 1950. Then has begun another struggle. The struggle to maintain our internal freedom, our intranational freedom, and that included right to freedom of speech and expression. Article 19(1)(a) has been strangely and peculiarly worded. You may notice that. All citizens shall have the right to freedom of speech and expression. It is not a simple right of, or rather right to speech and expression, freedom of speech and expression. When you think of American Constitution, the First Amendment, which is close to ours, it says freedom of expression and freedom of press. Whereas we have assumed freedom of press as part of freedom of speech, but what we have added is this freedom of expression. But the very phrase of freedom of expression, if you see judicially, it was first employed by Justice Brandeis in one of his judgments in 1921, later followed by Justice Black. But the one who used this phrase as such was John Stuart Mill in his essay on liberty, a brain expanding substance, if you can call a book that name, and you can read that one. We all know the right encompasses the right to dissent and the right to disagree as well. Well, if you want to examine, apart from the American jurisprudence on this aspect, if you see the European standards, a judgment in 1970s is very telling on that one by this ECHR, that's Handyside versus United Kingdom. And in that one, the European court observes a democratic society is one that can withstand all expression and welcome all information and all ideas, including those that offend, shock, or disturb the state or any sector of the population. And in fact, this is the phrase one of the young scholars has adopted, Gautam, for his book. According to that one, such are the demands of pluralism, tolerance, and broad-mindedness. Friends, when it comes to the Indian jurisprudence, no sooner than we had this constitution enforced, that very year, 1950, our pre-independent romance with the notion of freedom of speech has come in conflict. Then we woke up into the realistic compulsions of nation building and statecraft. In these 70 years, we have traveled from print to pixel, from news media to social media. Now we are in the post-truth era, dominated by digital news. Information is power, we know. It can tilt the balance and topple the establishments. So throughout history, the kings, the tyrants, the monarchs, even the elected governments never felt shy of holding the reins and imposing restrictions, a universal phenomenon. How it all began, if you go back to 15th century, a bit of history I may dig up. In 1439 or thereabouts, one goldsmith called Gutenberg in Germany invented a printing machine. For a decade, people did not realize its potential. But the real printing began a couple of years later. Then, next to 20 years, believe it or not, 2 crore books or volumes have been printed in Europe alone. In England, in 1476, the first book was printed. Then the crown claimed an authority to control printing as a right of prerogative. Then everyone should possess a license. That's called the royal imprimatur. The system of prior restraint remained in effect up to almost 1700s, when that legislation expired. If you think of the treason in connection with free speech and expression, it had its origin again in 14th century, 1350s. It lasted much longer than the licensing regime. Let me tell you about a person who printed an innocuous book, booked under this treason. His name was John Twain. In 1663, or about that year, he printed a book. Then the British officials arrested him. You know what that book contained? It only suggested the king was accountable to the people and that the people were entitled to self-governance. You cannot imagine what befell Twine's fate. He was convicted of constructive treason, hanged, drawn, and quartered. That means torn into pieces. Eventually, this doctrine of constructive treason was abandoned in 18th century. And the last limb of this draconian imposition is seditious libel. And that was in 13th century. It outlawed any false news or tales causing discord between the king and his people. The logic behind this doctrine is this: libel against a private person causes breach of peace, but libel against a government officials not only causes breach of peace, but also scandalizes the government. And it may shock to hear what followed when it comes to the libel or what constituted. Truth is no defense at all. If you take one particular case, again of 1704, Rex Tuchin, in that one the court declared a true libel is especially dangerous, for unlike a false libel, the dangers of truthful criticism cannot be diffused by disproof. The greater the truth, the more the libel. See how strange the logic is. And one of the most prominent personalities that has rebelled against this libel was John Milton. We only remember him for his Paradise Lost, but we'll come to the other aspects. If at all there is anyone who championed the cause of free speech then in common law world, it was Sir William Blackstone, you know, the commentaries of English law. He despised prior restraint and advocated only common law remedies of defamation and damages post-publication. Very recently, Supreme Court has said in Subramanya Swamy's case that those are the remedies you have, not the invalidation of 499 or 500. There is an interesting aspect noted in a book called The Law of Press Censorship in India that was by Soli Sorabji. He refers to Milton's Areopagitica. That's the book or the pamphlet he published those days denouncing pre-censorship. Milton was a young radical in his college days, a votary of free speech and freedom of expression. That was one of the earliest attempts at that. And he said, "Give me liberty to know, to utter and to argue freely, according to conscience, above all liberties." That's what he has proclaimed. That was in 1644. You know pretty well this Areopagitica was a powerful pamphlet against prior restraint and licensing. But the irony would have it, this powerful preacher of free press later became a government official in the regime of Cromwell, man who led parliament as a rebellion against the English monarchy, got the English monarchy beheaded, and had the first parliamentary rule in UK. And Milton happened to be his official, and he was given the task of censoring the free speech. Then Mr. Sorabji makes a very interesting observation in this context. Freedom of speech has always been more of an ideal than a reality. Indeed, very true. Let's see how that is true. History tells us everyone without power is a utopian, idealist, and everyone with power is a utilitarian, a practical man, rather. And lofty principles always yield to plain pragmatism. We accept that. If you begin with the country that we have adopted most of our litigious features, jurisprudentially speaking, Great Britain has no written constitution. Does that mean that its people have no rights at all? On the contrary, If you read any good book on American constitutional law, it will tell you the First Amendment does nothing more than constitutionalize the common law rights on freedom of speech. In India, if you read Abhinav Chandrachud's The Republic of Rhetoric, he forcefully argues that we enjoyed more freedom of speech. Is it all right? He forcefully argues that we enjoyed more freedom of speech during the British regime than in free India. Read, if you please. It has quite an interesting and a different take on the subject. But let's see how the academic considerations given way to these administrative compulsions, even when it comes to implementing the constitution in any free country, especially with written constitution. If you take American Constitution, it was the brainchild of the Federalists. There were two groups, Federalists and Anti-Federalists. The Federalists were dominant. They had this ratification. Then they had eventually even the 10 amendments first. And they largely drawn from the Articles of Confederation that was in 1787. Later, they introduced Bill of Rights. That was in 1791. The principal votary of this Bill of Rights and very constitutional reforms was John Adams, who was the second president. And as was the case with Milton, the government of Federalists that introduced this freedom of expression or freedom of speech very soon in 1798 itself introduced the Sedition Act, curtailing that freedom. And courts refused to interfere. That lasted until it eventually lapsed. Under that regime, many press persons were sentenced. That's as I said, in the UK, so was the case in the USA. Now let me see what has been the judicial path in interpreting this provision in the US, so that we can contextualize how the times have changed, because any constitution is an organic document and it's never been static. This principle of originalism does not apply, though some votaries are still there. Now, if you look at that one, in 1940, surprisingly, up to 1919, there was not much case law. Beginning from what is that year that began constitutional debate, rather American Supreme Court functioning, 1789. 1803 was this Marbury versus Madison. 5 years prior to that when it started functioning. Up to 1919, it never had any landmark case on this aspect of freedom of speech or freedom of press. Only when the war began, rather it was at its height, the First World War, America started drafting young people into army. Some pacifists started protesting. Then the courts have come down heavily. Government's been forced to legislate certain acts. They've restricted that freedom. Then they've started holding that not to speak is a facet of fundamental right to free speech. That was in Barnett's case. Then they have said your expression of dissent by wearing, say, like, for example, black flags, etc. Again, that was in Tinker's case. It was 1969. When you are conveying certain political message, to make it forceful using certain expressions which may offend or shock your conscience are permissible. That was in 1971. That was in Cohen's case. And you're contributing to a political cause, any funds, has never been a cause to identify you with that cause. That's been in Buckley's case. Then commercial products, whether they amount to any sort of free speech, that was Virginia Board of Pharmacy. So it goes on and on when it comes to the interpretation. Of course, as you have known, the famous aphorism of Oliver Wendell Holmes Jr., shouting a fire in a crowded theater could never be an expression of freedom. And that's how they've introduced certain restrictions as well. Here, what we may have to realize is America has started a journey in a quite an idealistic way. It wanted to have never had any restrictions. Soon, courts realized the folly of that one. Then they've introduced this doctrine of police powers. Kindly remember, all amendments of Bill of Rights in American Constitution are without limitation. Then the courts were constrained to introduce this concept called doctrine of police power. That res extra commercium, which were borrowed, was one facet of it. But we have no need for such theories because our Article 19 clauses 2 to 6 contained all sorts of restrictions that are required. Now, if you think of the decisions that have been rendered by the courts, in what manner they have been interpreted, we just have to see essentially Article 19(1 with its restrictive clauses has had two diametrically opposite concepts combined. That's what Mr. Chandrachud feels, Abhinav Chandrachud. That is continuity and change. You know pretty well, they're almost oxymoron, expressing opposite ideas. 19(1 says change. 19(2 says the continuity, rather 2 to 6. When it comes to the Indian experience, what has happened soon after the freedom can be realized after looking at what was the position before that. You know, in winning the freedom, you know pretty well, our first Prime Minister and also the first Deputy Minister, Prime Minister, that's Nehru and Patel, have played no less vital part than anyone else. And in fact, Sardar Patel was the chairman of the Advisory Committee on Fundamental Rights. In the committee's interim report, he stressed the importance of the fundamental rights and their enforcement through judicial review. On his part, Nehru has said, a fundamental right should be looked upon not from the point of view of any particular difficulty of the movement, but as something you want to take permanent root in the Constitution. A number of Supreme Court decisions have been quick to distinguish, but the free speech tradition in India from other jurisdictions. You take one of the best examples of that is Manubhai Shah case that was in 1992. You know pretty well that concerns Life Insurance Corporation. One particular scholar or a statistician researched on the policies of LIC, and he published an article in the newspaper, the Hindu, saying that what their policies are, they are unfair and unreasonable. Then, immediately LIC, through its one of the officers, has issued a rejoinder that was published. That apart, in its in-house magazine, LIC again had a denunciation of what has been proposed by that person, that Shah. And he wrote to them, all right, you have had your view on that one. Let me have my counter. But LIC refused on the ground that it is an internal magazine. You will not have any entry into it. So then he reached the Supreme Court, and it has said there's no way he has to be given. Speech and counter speech are the balancing forces of free speech. Some scholars have felt the jurisprudential progress of free speech has two facets. They call it one instrumental theory, the other one non-instrumental theory. You have heard about, again, if I invoke Oliver Wendell Holmes Jr., his saying of marketplace of ideas, then speech promoting democracy, or watchdog theory, still speech promoting the truth. These are all instrumental theories. I'll explain in brief what they meant by. They all posit that this theory on the concept of democracy. Now let's think of this non-instrumental theory. Friends, why I've been addressing on these lines is very simple. I know Goa Bar is quite an enlightened bar, and you are no longer students to listen to case law cataloged and belted out. I just wanted to put some sort of an idea into your mind so that you can as well discuss on these lines and see that in what different line we can say. My constant theme in any forum is that never ever depend on any precedent, because that limits our thinking, that kills our creativity. That's why only let's talk about ideas. So these jurisprudential experts have said two theories, instrumental and non-instrumental. And India has adopted both of them. But where lies the difference? I'll just explain in a couple of minutes. When non-instrumental theory, it treats speech and expression essential for the development of or the autonomy of an individual, and it need not underline any social purpose. If I put that in a nutshell, this instrumental theory is society-centric. This non-instrumental theory is individual-centric. All through, essentially, European jurisprudence is based on non-instrumental theory. They have said speech is for the speech's sake. It should not have any beneficial content for the society. I do what I please, so long as I don't infringe on your right.
Sir, may I just
Yes.
interrupt, sir?
Yes, please.
Sir, we have just some few minutes in the meeting. We're creating another link. We just send it over, sir, to you. Because of
I
the
didn't know
delay
that.
in joining.
Okay. I
Sir,
didn't know
we
the
are
time
just
limit.
creating another link. We will just circulate it, sir, in 2 minutes.
See, don't you think I'm spoiling your evening? I really feel sorry.
No, sir, it's only because there was some time lag in joining. That is why the.
Okay. I assure you, I can finish in 15 minutes. Give me a second link. I will not drag you
Yes, sir.
long.
I will immediately send this.
Sure do.
Yes. All colleagues may also join it. I'll share the link on the group again. Thank you. Post taka gela. Yes, student. Consider now WebEx. Sorry. We will be sending another link to the. Please check your See, check on the group. The link will be sent to the. Hello.